It is 8:10 at your kitchen table. Your new trust binder sits beside a $1,200 attorney invoice. You feel responsible, even relieved, until one sticky note says, "Move everything into the trust." That word, everything, is where a good estate plan can quietly turn into taxes, delays, and paperwork. So before you retitle another asset, put 5 red flags next to the ones that usually belong somewhere else. A trust can be useful. It can keep certain assets organized and may help your family avoid probate. But estate planning has 2 different levers: who owns the asset and who receives it later. Pull the wrong lever and a $500,000 account can become harder to transfer, not easier. This is education, not personal advice. Use it as a checklist for your attorney, CPA, or advisor. First, be very careful with retirement accounts, IRAs, 401ks, 403bs, and similar plans. These accounts have special tax rules. They are not ordinary bank accounts wearing retirement clothes. If you try to retitle a retirement account into your living trust, it may be treated as a distribution. On a $300,000 IRA, even one bad move could create a painful taxable event you never intended. The usual planning tool is not changing the owner, it is updating the beneficiary form correctly. That form can name primary beneficiaries and backup beneficiaries, often outside the probate process. Sometimes a specially drafted trust can be a beneficiary, but that is not a kitchen table guess. A 1% mistake on $500,000 is $5,000. Retirement paperwork deserves more respect than a sticky note. Your action step: confirm every retirement beneficiary form, including old employer plans you forgot existed. Now move from retirement money to medical money, because the next trap is quieter. Second, do not casually put a health savings account or HSA into your trust. An HSA is powerful because it can carry tax advantages when used for qualified medical expenses. But the account is tied to an eligible individual. A trust generally is not that individual. After death, HSA treatment depends heavily on the beneficiary. Spouse, child, and trust can mean different outcomes. Even a $12,000 HSA is real money if it pays future dental work, prescriptions, or premiums. Instead of retitling it, ask the HSA custodian how beneficiary designations work on your exact account. Also, make sure your family knows the account exists. Hidden accounts create scavenger hunts during grief. That brings us to asset 3, life insurance, where good intentions often create extra friction. Third, be careful putting life insurance directly into your living trust by default. A life insurance policy can usually pass by beneficiary form, not by the instructions in your will. If a $250,000 policy has clear living beneficiaries, adding a trust may not improve the payout. It may add questions, delay, or trustee duties at the exact moment your family needs cash. There are exceptions. If beneficiaries are minors or need protection, trust planning may be wise. And an irrevocable insurance trust is a specialized strategy, not the same as casually changing a title. Your simple step is to review primary and contingent beneficiaries, especially after divorce, remarriage, or death. Old workplace policies and small funeral policies count too. A forgotten $15,000 policy still matters. Now let's talk about the asset parked in your driveway. Fourth, do not automatically retitle everyday vehicles into your trust. Cars, trucks, and trailers come with DMV rules, insurance rules, loans, and state quirks. After an accident, you do not want an adjuster confused about why a trust owns your sedan. If the vehicle has a loan, transferring title may even violate lender paperwork or require permission. And remember, a $35,000 car can become a $12,000 car faster than you expect. Some states offer transfer on death vehicle registration, some do not. This is where local rules matter. A collector car or valuable RV may need planning, but your daily driver may not need trust ownership. Before changing a title, call your insurer, lender, DMV, and estate attorney in that order. The fifth asset is where paperwork can accidentally break an income stream. Fifth, do not casually place active business interests into a trust without reading the agreements. An LLC operating agreement, partnership agreement, franchise document, or buy-sell contract may restrict transfers. Move a $300,000 business interest the wrong way, and you may trigger consent requirements or breach terms. Some entities also have ownership rules. Certain trusts may qualify, others may cause tax problems. This is not just legal neatness. It can affect payroll, distributions, voting rights, and succession. The safer path is a coordinated plan: attorney, CPA, business partners, lender, and insurance review. Create a one-page ownership summary: what you own, where documents are, and who must approve transfers. Your family should not discover transfer restrictions while trying to keep the business alive. So those are the 5 red flag assets: retirement accounts, HSAs, insurance, vehicles, and businesses. Now replace the phrase "move everything" with a better phrase: match each asset to the right transfer tool. Some assets belong in the trust. Some need beneficiary forms. Some need contracts or state-specific options. Make a simple estate map with 3 columns: owns today, transfers at death, and who handles it. Write real numbers beside it: $480,000 IRA, $40,000 checking, $250,000 policy, $18,000 car. Because a missing form can waste weeks and a wrong title can cost thousands you meant to protect. Back at the kitchen table, the $1,200 binder is still useful. It just needs coordination, not blind stuffing. Before anything enters your trust, ask one calm question: is this the right owner or just the nearest bucket?